While most Americans will be focused on the heated presidential election on November 3rd, hundreds of incarcerated juvenile offenders, their families, and the families of their victims will be anxiously waiting for a decision by the U.S. Supreme Court in the case of a Mississippi man who is challenging his life without parole sentence. Brett Jones, now 31, was convicted in 2005 of fatally stabbing his paternal grandfather during a fight when he was barely 15. Due to Mississippi's stringent parole law, he was automatically sentenced to life in prison without parole. Mississippi's public defender, Andre DeGree, says Jones is one of 87 individuals in Mississippi who were automatically sentenced to life without parole for a homicide offense they committed when they were under the age of 18. A disproportionate number of these so-called juvenile lifers are black.
I don't know how you could ever say, well, I know this person is never going to change, particularly when you're talking about a child. You're talking about somebody, I don't think any of us are the person we were when we were 16 or 17 years old. There may be some people who just can't function in the world. I understand that that's possible, but to just say that I know based on what somebody has done when they were 16 or 15 or 17 years old, that they are always going to be a danger. I just don't think that there's any way for us to know that.
DeGree and many juvenile justice reformers are advocating for legislators in Mississippi to abolish life without parole sentences for juvenile offenders and develop a sentencing structure that holds them accountable but offers an opportunity for release. Over the past 15 years, the U.S. Supreme Court has forced Mississippi and other states to roll back some of their extreme penalties for children in four landmark decisions. In 2005, the Supreme Court banned the death penalty for children in Roper v. Simmons. In 2010, in Graham v. Florida, it also banned life without parole sentences for children convicted of non-homicide offenses. And in 2012, the court ruled in Miller v. Alabama that mandatory life without parole sentences for juveniles under the age of 18 are unconstitutional. The court said such a harsh sentence, which is akin to the death penalty, violates the Eighth Amendment's prohibition against cruel and unusual punishments. In 2016, the court made it clear in Montgomery v. Louisiana that Miller should be applied retroactively to all juveniles serving mandatory life sentences. The court's decisions were based on scientific evidence that shows the developmental differences between the brains of children and adults.
So what we know from research is that your brain develops from the back, from starting the back to the front and from the inside out. Okay. So, and what that means is that in the front part of your brain is the part that helps you make rational choices, that helps you stop and consider different options, that helps you say, this plan's not working, I need to go to something else, and to really think things through and not on a superficial level. That's the part of the brain that's the last to develop. That part of the brain, the frontal lobe, isn't fully developed until the person is in their late 20s. Now you juxtapose that lack of development with the part of the brain that likes risk and rewards and is susceptible to peer pressure. That part of the brain really comes on board in adolescence. So you have this person who's wired to take risk, who's wired not to be able to fully think things through. Those are some of the major differences in the adolescent and adult brain. But I think the important caveat is there are times when the adolescent can think like an adult. For example, when they're not emotionally aroused and when they're not with their peers, they're more likely to display adult-like thinking. Most criminal activities with kids don't happen by themselves. And often it's precipitated by some emotional arousal or them not thinking it through fully.
Because children have a greater capacity to change than adults, the U.S. Supreme Court said in Miller that trial courts must consider juvenile offenders' age and other characteristics of youth before resentencing them to a lifetime in prison. The court noted that juveniles should be given a meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation. And the court emphasized that life without parole sentences should be reserved for the rare juvenile offender who is permanently incorrigible, in other words, juveniles who are incapable of rehabilitation. The Miller and Montgomery rulings gave Jones and other juvenile lifers who were condemned to die in prison the legal right to have a new hearing to determine whether their sentence was appropriate under the Constitution or whether they should be given an opportunity for parole in the future. Jones had his resentencing hearing in 2015. However, his attorneys say he was unconstitutionally sentenced to life without parole again, despite undisputed evidence that Jones is a model prisoner who has made significant efforts to rehabilitate himself behind bars, even though he had no incentive to do so. Furthermore, they say the judge did not make any determination that Jones is permanently incorrigible before resentencing him to life without parole, which they contend is required under Miller. Marsha Levick, who served as a co-counsel in the Montgomery case, filed a brief in support of Jones' appeal.
I think that what the Supreme Court was trying to say in Roper, in Graham, in Miller, and in Montgomery was that we do need to recognize the humanity of these individuals. And that humanity is expressed and reflected through this unique capacity for change and rehabilitation that children have. And here's someone who demonstrated that in innumerable ways through the experiences that he had in prison. I'm sure aggressively taking advantage of every opportunity that was available to him, which would have been few because of his status as a lifer in the prison environment. I think the court missed the point of the Supreme Court rulings and did a great disservice to them. And ultimately, of course, a disservice to Jones.
Levick says the purpose of the resentencing hearing is to determine whether the juvenile offender is one of those rare juveniles who is permanently incorrigible and cannot be rehabilitated. But some state appellate courts, including Mississippi, have a different interpretation of Miller, and the Jones case is expected to settle the issue.
The Mississippi Supreme Court has held that the finding of permanent incorrigibility, a specific finding by the sentencer, is not required. That the only thing the court has to do is consider any evidence presented and then pronounce sentence. And what Jones is asking the U.S. Supreme Court for is clear direction there and to say, before you can be sentenced, there must be a specific finding of permanent incorrigibility. But I think when you don't have a clear standard for who should receive this rare sentence, then it's just going to be left up to someone's feelings. Then we have no real appellate review of that.
Most of the individuals who receive life without parole sentences are men and women of color. And one of the values of having something like a requirement of a very specific finding, like permanent incorrigibility, is that it constrains discretion. Discretion is a good thing. We don't want mandatory sentences, but you also don't want unfettered discretion that is unchecked and that an appellate court can't review. So by having something like a very specific finding that a judge has to make, like permanent incorrigibility, if done right and done well by the parties to the proceeding, it also gives an appellate court an opportunity to examine that record, to see whether or not the judge made the proper decision. The hope is also that it eliminates the racism that infects our system, that still drives so much decision-making in the justice system.
If the Supreme Court decides Jones' sentence is unconstitutional, he would finally be eligible for parole. This would not guarantee that Jones will ever get out of prison because he would still have a life sentence, but it will give him hope and a chance to prove that he is not a lost cause. Although a win for Jones would be a huge step forward, Degree says children in Mississippi will continue to be at risk for being sentenced to die in prison until the legislature follows the lead of other states and abolishes life without parole for juvenile offenders. This is Shirley Smith with the Mississippi Center for Investigative Reporting.